I want to thank David very much for joining us here tonight, and to commend his articles and his books to everyone. All of them are really outstanding. His most recent on Dodd-Frank, entitled "The New Financial Deal," is really the best on financial regulatory reform out there right now. I would have brought my own copy for you to autograph, but it's on loan, as it so frequently is, to other colleagues. And also to commend your work as a professor. It's very rare as an attorney to encounter anyone who's been a student while you've been at Penn Law or at NYU Law who hasn't talked about how you've helped shape the student body, in particular the students who are involved in Christian activities on both of those campuses. So thank you for those. I'd like to start going back to the trial of Jesus. That you use as an example of the failure of a legal code. You mentioned that Pontius Pilate had a number of outs under the Roman code that he could have used to bring about justice to the plaintiff Jesus. But you also mentioned in your manuscript that the Mosaic Code would have prohibited the chief priest from getting involved in the trial in the first place. And so what do you say to a secularist, to someone, a champion of ultimate justice under the legal code, a materialist, who would say that in the case of Jesus' trial, the Mosaic Code actually worked, but for the failures of men, in particular the high priests, Pontius Pilate, and why is it that the Nicene Creed says that Jesus suffered under Pontius Pilate and not suffered under the Roman legal code?
That's a great question, and as you're saying that, the phrase that occurs to me is a phrase that has nothing to do with your question. When there's an accident of some sort, we often ask whether the accident was due to mechanical failure or human error. And one thing I would say is it's impossible to eliminate human error. So, which is another way of saying that you just can't make the legal code that is so perfect it makes misuse impossible. And the general tendency is the more you try to do with the legal code, the more you create opportunities for human error. You inevitably put more and more authority in human hands, and you inevitably have abuses. So I would focus on the human error part of it, which is, I think, something that at least the materialists I know tend to downplay. I mean, they tend to be very alert to human error in other perspectives, but less alert to it in their own perspective.
So if the materialist said, what about an evolutionary tweaking to the Mosaic or Roman codes? What about a common sense rule that territorial governors can't swap prisoners or require, having an appeals process? You would say that still follows your thesis, because both of those would be limiting laws on the code. It would limit the power of individual magistrates.
Yes, and I also would say it will break down at some point. It won't work. So, I mean, one thing that, since most of us here are lawyers, that when you think of the Roman trial, probably most of us think of the relationship between law and equity. Historically, that exceptions get carved out of the strict application of the law to try to deal with situations where something seems off. And that's the kind of thing that Pilate had at his disposal. But even those exceptions inevitably are imperfect, and there will either be a situation they won't cover, or there will be somebody who will abuse them. So I think that there just is no evidence of a fully effective legal code in any context, or the way the mid-20th century theologian Reinhold Niebuhr would have put it is, justice is only possible, he would say, between two people. That once you get beyond two people, it's impossible to have justice. I think he was a little too pessimistic, I think, but I think the general idea is right.
Moving on to your example of the Voting Rights Act and the Civil Rights Act, I wasn't expecting an example of quote unquote good law to come after America's penultimate period of believing that the legal code could provide ultimate justice in the 1920s. And in fact, I was reminded of the misquote often attributed to the director of the Patent Office in 1899, who's misquoted as saying that anything worth inventing had already been invented in 1899. And I would have thought that by the second half of the 21st century, someone who does not put their faith in superfluous law would be of the opinion that all the law worth making would have been made sometimes over. And in particular, I know you described the relational aspect of the Civil Rights Act and the Voting Rights Act, but could you explain its relation to the 14th and 15th Amendments, which on their face seem that they should have achieved what the Voting Rights Act and the Civil Rights Act were intended to achieve, and thus why weren't they superfluous on top of the 14th and the 15th Amendments?
So it's a great question, and the way I would answer it is the Voting Rights Act and the Civil Rights Act, in a very real sense, were put in place to make the Civil War amendments enforceable. I mean, I think you're exactly right that the civil rights, the 13th, 14th, and 15th Amendments should have taken care of these issues if they had been enforced consistently, and the Voting Rights Act and the Civil Rights Act were meant to in a sense, to put teeth to them. And the reason that those acts worked, in my view, and this is something that Stuntz agreed with, is where a lot of legislation falls apart is where it tries to do too much, and it tries to systematically police something that we don't have the capacity to systematically enforce. One of the really interesting things about the Voting Rights and the Civil Rights Act is they created enforcers. They created people who had a stake in the ability to vote and a stake in the ability to be treated fairly in the workplace and elsewhere, so that we didn't have to quadruple our police force to enforce it the way you would have had to quadruple the police force to enforce prohibition. We had the enforcers out there, and they have an incentive to enforce it under the Civil Rights Act in particular, but also to some extent under the Voting Rights Act. And that, to me, was a big part of the genius of those acts. That, you know, they're not perfect, and we're still arguing about the Voting Rights Act now and its future now. But they created a mechanism that did not require superhuman enforcement or superhuman activity. It required ordinary people to stand up for the rights that were embodied in the acts.
In addition to the authors of the Voting Rights Act and the Civil Rights Act of the 1950s and the 1960s, you cite as the only other sort of moment of clairvoyance and human civilization as the Constitutional Convention, also in the United States. But isn't that a bit harsh? Surely any author of a legal code with a standard of evidence that would be beyond reasonable doubt. And here I'm thinking of the jurist Blackstone saying, better that 9 guilty men go free rather than 1 innocent man go to prison. Shouldn't anyone making that statement clearly understand the limits of the legal code and not be arguing that their legal code, in this case, the English Common Law Code, would be bringing about ultimate justice?
Yes, and so one way I'm just going to, I'll say a couple things. The first will answer your question, and then the second won't answer your question. I think a lot of the things that I identify as problems in our system of justice are misuse of the laws that we have. I mean, it's maybe unfair to treat our Constitution and subsequent laws on the same level as a lot of other system of laws. As a system of justice, they're very, very good by human standards, but they're not perfect. And historically, we have had a tendency in this country to love law too much and to think that law can do too much. And after the Civil War in particular, there was a period of optimism that looked really different than the founding era. The other thing I'll say has to do with the idea of beyond a reasonable doubt. We all know that as the standard that that makes it difficult to convict somebody of a crime, on the view that we would rather have some guilty people go free than an innocent person to go to jail. The history of beyond a reasonable doubt is quite remarkable, and historically, beyond a reasonable doubt actually had precisely the opposite objective. It wasn't designed to help people to go free. It was designed to put people in jail, or actually to make capital punishment possible. There's a wonderful book about this by the Yale legal historian Jim Whitman called The Origins of Reason Beyond a Reasonable Doubt, or Origins of Reasonable Doubt. Historically, juries, it was almost impossible to get a jury to convict a criminal defendant because they took Matthew 7:1, judge not that ye be not judged, really seriously. And they felt that it had eternal significance, that if they were improperly judging another human being, that there were serious consequences for that. So historically, it was almost impossible to get a jury to convict. And so the beyond a reasonable doubt standard was meant to be a comfort to jurors and to tell them, if you're sure beyond any reasonable doubt that this person is guilty, it's okay to convict them. You know, you will not be punished. I often think, you know, if we took biblical teaching about these issues as seriously as they did then, it's another way in which I think our legal system would look a lot different. I think we would be wrestling with very different kinds of issues.
Terrific. Well, I want to open up the floor, but I want to ask just one more question of a biographical nature. Your opinions on financial regulatory
I knew you were going here sooner or later.
I was going to say are not popular within necessarily academia. Certainly, your views on a Christian perspective on life must put you in even greater minority. What lessons have you learned working in a place and in a field where your thoughts and opinions are different than the majorities, for people in the audience who might find themselves similarly placed?
So it's a great question, and I'll do two things, one of which is answering the question and one of which is not. This time I'll start with the one that's not answering the question. One thing that I think a lot about, maybe not as much as I should now with the popular writing that I do, from a Christian perspective, and this is the part that's not answering Peter's question, is what is and isn't appropriate in conversation and debate publicly. So that some of my, if you were, don't do this, but if you were to Google some of my op-eds and things, I'm fairly polemical in some contexts. And I think a lot about, you know, is it wrong to be polemical? You know, when is it okay to be polemical? When is it not okay to be polemical? And I don't think polemicism is always problematic. I think there's a time and a place for it, and I seem to find myself in the time and the place all the time for polemicism. But it does make me think about making sure that the values I'm focusing on in one area are also evident in another area, and that's one of the challenges with that. But that wasn't your question. Your question was more kind of, do I face pushback as a Christian in academic circles? And the answer, and what lessons that might be relevant to other people. I mean, the first general thing I would say is it's really, the consequences are really different depending on where you are. So if I were a sociologist, acknowledging that I'm a Christian could be professionally devastating because there is a real hostility to Christianity in sociology. True in some areas of the sciences as well. It's not so true in law schools. I mean, an interesting thing about the obsession with diversity in law schools is I'm considered really diverse. You know, and as a white guy, it was really hard for me to get into the diversity corner, but I came up with something. And that is, I'm the only evangelical Christian in most circles where I am. And people take that seriously. And so I haven't been hurt on the margin. In some respects, I think I've been helped. The negative consequence, and this might change, actually with this book, this might change a little bit because it's going to put some of my ideas kind of in people's face in a way that they aren't necessarily now. But in my circles, the biggest issue is that my writing in these areas, which I think is every bit as scholarly and as serious as my writing about financial distress and bankruptcy and financial institutions, is really treated as a hobby by many people, not seen as serious scholarship. So it's more trying to get that work taken seriously than being discriminated against. I mean, just to finish with one note on this, I'm actually of the view that someone who is politically conservative is more likely to be discriminated against in legal academic circles now than somebody who's an evangelical Christian. That there's more discrimination against conservatives and some of it is quite overt and candid. As an evangelical Christian, I don't feel that so much, but that's where I sit. It's not necessarily where y'all sit.
So this book could be less controversial.
Well, you know, if nobody buys it, you know, if nobody sees it, my legal career is going to take off. But if not, you know, I mean, if a few people do read it, who knows? Because it clearly it's I mean, it's going to be a small, simple, understandable book, but in some respects, it's a summation of a lot of things that I've been thinking about.
Terrific. Well, any questions? I think I've bought everyone enough time that everyone should have a question by now. Yes, right there.
Kind of two very broad questions. You just make some comments. The first one is, in terms of kind of your audience or audiences, and give an example of that. You know, when I didn't know this book, and so I was attracted by the justice theme, obviously the spiritual or Christian theme. But I know for justice, it's a very, you know, it tends to be very particular kinds of issues that people resonate with. You know, justice is local. It depends on where, you know, the issues and so forth. So I'm kind of thinking, what kinds of audiences are you wanting to touch, you know, broadly speaking? I know you're wanting to go beyond kind of a scholarly legal audience, for example. And then kind of the other question is, you know, let me just give you a specific case. So obviously Ukraine is in the news. And, you know, I found it striking that, you know, when you're in Europe and you talk about contract and rights, people use legal language. But if you're in Ukraine or Russia, because there's very little faith in the judicial system, people actually talk in terms of right and wrong, moral terms. You don't hear that in Europe. You hear the morality there. But I wanted you to use that as an example of some of the themes you talked about: complexity, speed at which change occur. You know, what to do in situations, you know, where the judicial system, actually the laws are on the books, but because it's a power situation, power is what rules, and then how that affects, you know, even especially if you're speaking to non-Christian audiences, what do you want them to say if you were speaking to a specific situation? So sort of two different questions, just some comments on each.
Yeah, there's a huge amount in that, obviously. So starting with the what audience, what audience is. I'll give an answer and you can come back if it's not getting to exactly what you want with the question. I've had a lot of discussion with people about who this book should be aimed at, and my answer is that my particular target audience is Christians who are having doubts about their faith, Christians who want to think and read about what are perceived to be big problems for Christianity, even if they're not having doubts about their faith, but want to think through issues like suffering and consciousness and justice I'm trying to put on the map as well. And those who are not Christian, who might be persuaded with the right set of arguments to give Christianity a look, as a friend of mine would say, to give the book a look. So that's sort of the general answer on the audience question. I'll say something. It seemed like you might want to talk a little bit about the justice angle and what I'm thinking about that. And I want to say something. I'll say two. I'll get your second question, and then I'll circle back. So on your second question with the Ukraine and the fact that there is a lot more talk about right and wrong and less talk about rights, and a footnote and law. Footnote on that, we've had a big debate, as many people in this room know, about rights talk and whether we think in legal terms too much. I tend to think that we do think in legal terms too much. And one of the counterintuitive things about a situation in a place like Russia or Ukraine is that they're in a world where they have to focus on changing people's hearts because the law isn't going to change things for them. The law is not going to be enforced even if they could get the law. And I actually think that's the right place to be. I wouldn't say what our objective should be to bring down the legal system and have an ineffective legal system. But I do think that we should be focusing a lot more on right and wrong and changing people's hearts, and a lot less on whether we can get 51% and get a particular law put in place. So that's what I would say about the second one. On justice, I have lots of thoughts of different kinds on this, and so I want to say something. I probably don't want to say this, but I'll say something anyway. So right now, if I were to ask what's the coolest justice movement out there in the Christian world, if I were to pass around a sheet of paper and have everybody write something down, I bet half of you would write down International Justice Mission is the coolest, and they are really cool. I don't want to criticize that at all. For those of you who don't know what it is, it's an amazing ministry that uses laws that are in place to free people from various forms of bondage, often sexual slavery, but not always. I think that they're amazing, that what they do is amazing. But I guess what I would say is, if we really want to think about justice, we also have to think more broadly than that. We have to think about, well, what do we do with these people when they're out of sexual slavery? And the current model for that is we teach them how to do crafts to sell, which it works in some cases, but is not a model that I believe can be scaled up. I don't think that ultimately is a holistic answer to the question, how can we truly ensure justice? So I guess what I would say about this is it's really important not to think narrowly about justice. I mean, we have to think about larger issues as well. And I thought Peter was going to ask me to talk about what does all this have to do with financial regulation. And he didn't ask me this question, but I'll answer it because I have an answer for this one. It might be wrong, but I think we have to apply the same sorts of principles. When you talk to people about what should we do about the crisis that we've been through to make sure that doesn't happen again, you tend to get two kinds of answers. One is, we just need people who are more honorable on Wall Street. We need people who have values and are not just looking for dollars and cents, that they have real character. The other answer you get is we need a bunch of new laws to punish people who misbehave and to make sure that they don't misbehave. Either one of those answers by itself, I think, is going to be ineffectual. I think that you can't just tell people they need to be more honorable if you have a legal system that encourages misbehavior, as I think we have some financial laws that do. The analogy that occurred to me as I was thinking about this is there was a movement in the 19th century, a Christian, sort of Christian heretical sect movement called perfectionism. And what you did is, you were so holy and you worked so hard to be holy that men and women could sleep on the same bed naked and they would not have sex. That perfectionism meant that we were beyond normal temptations. That didn't work. A system where the laws are structured to give people a huge incentive to take risks, as our financial laws are, and there's one tax law in particular that's unbelievable. If you've got laws that are structured that way, people are going to do things that look inappropriate. And so I think you have to be thinking both about the moral qualities, character formation, and about the incentives that you're creating through law. This was not either of your questions. But
David, if I could ask a follow-up there. You mentioned that we should expand our scope of justice to include, in the case of some of the clients or the the people that IJM is helping, vocation and work. Does that mean the corollary is that we should enlarge our basket of rights that we think justice is meant to defend? And here I'm thinking of, in particular, as you know, in Western countries, having a right to work is not something that is traditionally included in a constitution or a charter document for a country, but in a number of African countries and former Soviet republics, it is.
Yeah, this is a great question, and so I guess I'd answer it this way. In Europe, the basket of rights, the basket of human rights is much, much broader than what we think of as rights that we have under the Constitution. That's great in some respects because it's a broader, it's a more holistic perspective on what human flourishing requires and what it entails. But it also becomes very, very difficult to implement. And what seems to be happening in Europe is it's separating into different categories of rights. There's some rights that are really inalienable and have to be fully protected, and other rights that are rights in name but don't have the kinds of protections that we associate with constitutional rights in this country. In this country, we've gone in the other direction toward defining rights a little bit more narrowly, but giving them more teeth. I guess my view is that constitutionalizing rights is not the optimal strategy. I think we're right to stick with a smaller basket of rights. But I do think that it's crucial to have conversations about what we expect out of our economy and what we expect out of our markets. And I'm one that I believe the income inequality problem is a real problem. And I think that we need to do something about it. I don't think that means a right, as people talked about in the 60s, for everybody to have a living wage. I don't think that's the way to do it. I think there's not one perfect answer to the question, how much markets, how much government do you have to get the right mix? And I think the answer may be different in one generation and another. So the less you entrench your vision of what this mix should look like, I think the better. So I would not expand our conception of rights, but I would encourage a conversation about what we should be doing in that range of flexibility that we have.
Other questions right here.
I knew you weren't going to stay silent forever, Richard.
That's Professor Skeel's way of saying that I'm also a law professor.
And we talk about these things.
Yeah. So I'm a little concerned that your notion that the Christian critique of other ways of going about law, which is that they make a false, they being materialists and maybe others, make this false assumption that humans are perfectible, wouldn't be accepted by those other parties. So if we were to go to, you gave the example of prohibition. Let's say you were talking to someone who was advocating prohibition, to go back in time and saying, oh, you're making a great classic error, which is to assume people are perfectible. They would have said, no, I'm not. I know people can't be perfected, just like you know that. We agree on that. I'm simply saying that people can be improved, and that law has a role in improving people sometimes. And this is an area in which humans can be made better in their moral conduct by not being able to drink. And I don't hear you saying that law has no role in improving people. That law has no role in making people better. So if that's the case, then how do we operationalize this concern about this what you think, and I think it's right, a false assumption that the law can make people perfect? When the people who would be arguing against you on the other side, I don't think would say, oh no, I think people can be made perfect and I'm going to make a perfect person with this law. But instead you're arguing about how much human improvement can be effected through the legal system. And is there any more concrete kind of way of striking the difference between, or describing the difference between how much improvement you think is possible and how much improvement maybe materialists would think is possible?
Yeah, this is a great question, which I think has several different strands in it, which I don't know if I'll be able to keep them all together, but in trying to answer. So one thing I would say in the question, does law have a role in improvement, in improving people? And my answer to that is absolutely yes. It does. It plays an important role in not just correcting people, but improving them. but almost invariably less of a role than we think it does. That we almost invariably expect too much from the law, and I talk about this in a variety of different ways in different places, but one argument that I make that's related to the things I've said tonight is that to the extent that you enact laws that cannot be systematically enforced. In a good test case on this, a really hard test case, I think, is anti-prostitution laws. But that's another conversation. But to the extent that you enact laws that cannot be systematically enforced, they are almost invariably going to fail, and they will often be have exactly the opposite effect of what you expect. So that if laws are enforced in a discriminatory fashion, they can have the effect of undermining precisely the moral norm that you were trying to strengthen. And one can argue, there are arguments on all sides, but one can argue that prohibition had that kind of effect. So I do think law can improve. I think it's essential not to do more than that with law than we're willing to support with all of the resources it needs to be enforced. So one way of looking at this is you got to put your money where your mouth is. And we have a tendency in this country, particularly in the last century, to put our mouth out there but not our money. To pass a law. Whenever there's some terrible new type of crime, we pass a law against that crime, but we don't do anything about it. So that's part of an answer to your question. The part about the materialists, that's really hard, and I need to be careful not to suggest that the view that I'm critiquing is every materialist view, because it's not. Not all materialists are over-optimistic. So really what I'm identifying is what I see as a tendency to assume that that we're capable of doing, that we're capable of achieving great things with law. And the way I see this in what I've read of the Steven Pinker book so far is he just sort of generalizes about government. He makes these vast statements about government stops that and government helps this without getting into the nuts and bolts of what exactly is government doing and what's it doing well and what isn't it doing well. Another point you could make in here is, which I thought you were going to include in there, and maybe it was part of the subtext of your question, is Christians haven't been so great on these issues. So if you talk about prohibition, who was it that was promoting prohibition? Well, it was Christians, and not just Christians, but largely Christians. And this same atheist that I keep referring to, one of his complaints about my book is what he called the true Scotsman defense of Christianity. That every time that there's something Christians did wrong, I say, a true Christian wouldn't do that. To which he could say, well, a true materialist wouldn't do that. But an argument that I want to make here, and I make in the book, is this is all true. Christians have messed up in many ways, have misused power throughout history. But Christianity, in my view, is self-correcting in a way that at least optimistic materialism isn't. So that when Christians abuse power, it's because they're not listening to Christ, not because they're listening to Christ. Whereas when a Marxist abuses power, I think there's a stronger argument that it's because they're listening to Marx, not because they're countering what Marx would say.
Right here.
David, you talked about a premise that really struck me. You said our dignity as Christians comes from God's love. We all have the same dignity because we are all equal to be loved by God. And thus we have an obligation to promote the flourishing of others and seek their welfare. And it struck me because in our present context, the 21st century context, society seems to be going away from this standard. You mentioned the growing income inequality. We also have this great partisanship in Washington that seems to have created this gridlock in government. Things just seem to be trending away from this kind of standard. So my question is, do you think it's somehow related to a weakening or waning of Christianity on the body politic, and this is asking you to be a bit of a visionary, but would
Not something I've ever been accused of.
would a revival or some kind of reawakening in terms of Christianity start to, move us back toward that premise of Christians being a source of societal flourishing?
It's another great question and a really hard question to answer. So I'll just say a couple things about it. And one is, I do think that those of us who are Christians have been part of the problem, and I think it is connected with the secularization of American culture. I think that as the sense that America is generally Christian, what used to be called the Protestant consensus in American life, as that eroded throughout the 20th century, particularly the second half of the 20th century, Christians felt beleaguered, and in many respects we lashed out. And I mean, a friend of mine made the comment, who was involved in some of the early evangelical legal efforts in the 1970s and early 80s. He said, for many, many years, Christians didn't get involved in politics, kind of stayed away from politics, and then finally, as things were being taken away, or so it seemed, Christians came out with a Bible and a baseball bat, is what she said. We came back with a Bible and a baseball bat. And I think that's the way Christians are perceived, or have been perceived in the last couple of decades in American life. So I do think that part of the problem is a shift in the moral structure of this country, but I think Christians' response to that shift has been part of the problem as well. There's a huge backlash, obviously, against evangelicals in the last generation. I do think it's possible to reverse that, and I think that that's one reason, not the only reason, but one reason why a ministry like IJM has such a resonance with so many people, because it's a place where the perception is we can all agree. We can all agree this is injustice, and we ought to get to do something together about it. And it seems to me, to the extent there are more opportunities like that, I think there could be sort of a reshaping both of what Christians are doing and how we are perceived. And just a footnote on that, I mean, one of the most encouraging things that's happened in the last generation, I think, is the fact that so many Christians have gone to difficult areas of the world and seen suffering firsthand. And I think people bring that perception of suffering back here, and it changes the way they think about their priorities. So I am cautiously optimistic in the sense that I think things are going to be getting better rather than worse, but I think they're not great now, and certainly the political crisis that we're in right now certainly doesn't help things.
On the right side, gentleman with the beard.
It's an advantage of having a beard.
One of the things I sort of see on the fringe of what you're talking about is the theories around legal structures. So, for example, you've got with the trial of Jesus, one of the parts of the breakdown is this passing the block between Pilate and Herod, as opposed to, say, one of the successes is the Civil Rights Acts of the 60s, where you get, rather than things happening on the fringes of jurisdiction, you've got things being centered in, as you put it, people with new states and seeing these laws enforced. On sort of like a far out there, then you have Paul's admonition, don't go to the secular courts to solve your problems. So can you speak a bit more about the way that legal structures play a role in the justice paradox, both on the pro and the con?
Yeah, it's another tricky question. I might have to go back and forth with you a little bit to get just what you're getting at with that. I mean, part of my reaction is the same reaction I had when Peter raised this issue, and that is one of the lessons of the trial of Jesus is that even a really good justice system can't guarantee justice. I mean, I don't mean to suggest that the Jewish legal system or the Roman legal system were bad systems of justice. They were the finest systems of justice in the ancient world. So that's one of the takeaways about it. I guess I have some scattered thoughts, and then you can come back, because I feel like I'm not completely answering your question. But I do think that thinking about whether a law can be enforced systematically is important. I think it's important to think about who the beneficiaries of the law are, and what the impact of the law. What impact it will have on them, and also what impact it will have on others. I don't think that we've been perfect with these kinds of laws. So we wrestle a lot with things like access for people with disabilities, which has some of the same qualities as the civil rights acts. I think we've made some progress there, but I think it's not quite as clean. And there is a tendency now for a wide variety of folks to want to harness the genius of the civil rights movement and the genius of the civil rights laws. So it's possible to have too much of a good thing. If every perspective has a law that they can enforce, I think you can have problems. You can have laws that are that in concept might be attractive, but create more problems than they solve. You said something about periphery as opposed to center, and I wasn't sure what you were getting at with that.
So with the trial of Jesus, one of the reasons they were able to pass Jesus back and forth between the two legal systems is because each one had a way to say, this isn't my fault. This is their
Right.
And so it raises a question, in my mind at least, of jurisdiction, which can be seen more broadly as legal structures. So not maybe so much as the individual citizen or citizen groups having interests in things, but the legal structures themselves being set up to create either geographical or topical jurisdictions that then become a part of the paradox.
Yeah, that's really, I have a reaction to that. Which I'm not sure if it completely answers your question either, but it triggered a thought, and that is, or a couple of thoughts. One is, it seems to me that when you look at the Bible and think about what the Bible suggests about systems of justice, I wrote a little piece on the Mosaic Law with a theologian, actually, that looks at this. The orientation seems to be very local, so that when you look at the law in the Old Testament, it is at the lowest local level that most decision making is done. Often at the gate to the town is where the elders make the legal decisions. It's very similar to a concept we would now call subsidiarity, or that's the Catholic version. On the Protestant side, it would be Abraham Kuyper's sphere sovereignty. It's a similar sort of principle. And Kuyper was, well, as both the Catholic and the Protestant versions were biblically oriented. And so one thing those fragmented jurisdictions suggest is, I think, a good thing, which is that the level that you want to make do as much decision making as possible is the level of people who either know the folks who are involved or have an understanding of both the prosecution and the defense, as it were, in a particular case. As with every system of admirable justice, there are difficulties with that kind of system. And one difficulty is the possibility of punting if it's a difficult issue, and of jurisdictional competition of various sorts, which sometimes can be a good thing, but also can be a bad thing. And I think you do see that in the trial of Jesus, a desire not to take responsibility and to use those jurisdictional boundaries as a way out rather than a way to address a problem. That's an interesting insight.
Right here in the classes.
I actually probably come from a bit different perspective than I actually working for a major for an investment bank as an equity salesman. And one of the things I constantly bump up against is this notion of material inside information. What exactly is it? when do I have it? And,
Well, you can ask the guy in the back of the room who's going to be taking my corporation's final in about a week what the answer to that question is.
So I guess just like I live in this every day. We're constantly faced with this dilemma of information, and how do you see the justice paradox sort of fitting in this? I mean, what's the solution? By the way, fair disclosure, I haven't read your book yet. The other book on reform.
Okay.
That's now on my list. So.
So another really big, really difficult issue, and as we used to say in law school, this is a very difficult issue that does not admit of an easy solution. That was the first sentence of your exam answer to every question, unfortunately. So, I mean, the information issue is a very difficult issue. I'll say one thing about the insider trading laws, which is what you're referring to particularly, is they are trying to balance a couple of different things, and they do not balance them perfectly. And there are lots of problems. There are enforcement problems, there are scope problems. And the classic example of kind of on the opposite side from the side you're on in recent years was Martha Stewart was accused of insider trading about a decade ago. Pretty much everybody, I think, thinks that she was engaging in insider trading. She went to jail, but she did not go to jail for insider trading because it was impossible to prove that she had engaged in insider trading. So the laws are trying to balance a couple of different things. One of the things that they're trying, in my view, what they're trying to do is to reward people who generate information that other folks don't have, which is the kind of thing that you're doing, presumably. Talking to people, reading things more carefully, making connections that other people won't see. We want our markets to reward people who do that well. On the other hand, we're worried about people who have access to information inappropriately and who cheated to get access to that information. And one way of looking at the insider trading laws in particular, and many information laws in general, is they're trying to balance these two things. They're trying to leave enough room so that people can go generate information, which overall is a good thing and is productive on the one hand, but on the other hand, prevent, to the extent possible, people from cheating, first because we think cheating is wrong, but also because historically there's been a widely held view that if people don't think the markets are fair, they're going to be hesitant to be involved in the market. So the insider trading laws are trying to balance these things, and they do it in a really messy way. You know, if you want to talk about some of the specifics, I'd be happy to talk about it. You probably know as much about it as I do, but the current rules are really, really messy.
Terrific. And one more question, the gentleman in the gray turtleneck, please.
So you've talked tonight about law with a light touch, the limits of law. So one, I guess I have two questions I think are related somewhat. One is, I think, straightforward, but maybe not. The other one is broader. One is, do we take from that then that you would endorse a more limited or small government view? Two is, do you speak to sort of this kind of competing interests in our society, or competing visions or passions? One is, for lack of a better phrase, behavioral or moral permissiveness versus, the instinct to regulate and pass law and be legalistic and pass a law for sort of every problem that we encounter. Do you see those things as somewhat related, or how do you see the relationship between those two things?
Another really interesting question. So on the first one, on the small government question, that's the easier one to answer. I do tend in that direction, but I'm not a small government purist. I mean, I do think that some of the 20th century expansion of American government has been a good thing and not a bad thing. And I actually think we're at the cusp of another rethinking of all of this in a variety of different dimensions. But I tend more towards the small government than toward the big government side. On the permissiveness versus law, I think that's really interesting. I mean, what it makes me think of is a tension I referred to, which I think is similar in some respects, but it's different, and that is the tension between equality and liberty. That we want ideal. I think we're concerned about income inequality, but we also want to reward people who work hard and who are successful, just to give one example. So there's an inevitable tension in justice between equality and liberty. Almost anything you do to increase equality is going to restrain liberty in some way. So there's a trade-off there. You're talking about a slightly different trade-off between permissiveness and regulation. I guess what I would say about that is I think that we are in a deeply incoherent place on that issue as a society right now. So, anytime you pick up the New York Times, you will agree that there is an obsession with permissiveness and a criticism of anything that seems to limit people's ability to express themselves on the one hand, but on the other hand, same people who are extolling permissiveness in one area are insisting on legislation and regulation in another area, and we could put examples to that. And I think on both sides of the political spectrum, I think there's really a deep incoherence that it's not that we're balancing the tension between permissiveness and regulation, but that we're trying to do both obsessively at the same time. And I think that's part of the confusion a lot of people feel right now. That's a really happy note to end on.
Thank you, Peter, for moderating. Thank you, David.
Oh, you're quite welcome.
Let's give one round of applause.
Thanks, David.